David Leong, can you hear me?
I can hear you, Dr. Smith. How are you?
I'm okay. Thanks very much.
Gary, can we do a mic check with you, please?
Can you hear me, David?
I can, thank you. Hi, Carla. Can we do a mic check, please?
Yes. Hi, can you hear me okay?
Yes, thank you.
Thank you.
Hi, Sylvia. Can we do a mic check, please?
Good afternoon, everyone.
Good afternoon. Thank you. Joseph, can we do a mic check, please? Joseph Nguyen.
Good afternoon.
Good afternoon. Thank you. Charlie, can we do a mic check, please?
Good afternoon.
Good afternoon. Thank you very much. Hi, Carly. Can we do a mic check, please?
Hello, this is Carly.
We can hear you. Thanks. Hi, Molly. Can we do a mic check, please?
Good afternoon. Can you hear me?
Good afternoon. Yes, thank you.
Thank you.
Thomas, can we do a mic check with you, please?
Yes, I'm here.
Thank you. Judge Zahner, can we do a mic check, please?
Yes, I am here.
Good afternoon. Thank you.
Thank you.
Miguel, can we do a mic check, please?
know who we can blame for that.
Hello, Sheriff Smith. Can we do a mic check, please?
Someone has the mouse down there.
Can you hear us?
Yes, we can. Thanks.
Thank you.
All right, Dave, have you mic checked everybody?
As many as we can get, Supervisor. Go right ahead.
All right, then I am going to call to order this Public Safety and Justice meeting on Thursday, May 6, 2021 at 2 p.m. And I shall turn to the clerk to call the roll.
Vice Chairperson Wasserman is not here today. Chairperson Ellenberg.
I am here.
Thank you. A quorum is not present.
So the implication of a quorum not being present for all of you listening is that I cannot take action alone as a single supervisor, which means, for example, we won't be able to approve the minutes today, and I will not be able to ask for any follow-up reports or items from any of the presenters. However, I believe it is still very important to hold the meeting in order to hear the presentations and ask questions and hear from the public, as this is part of our civic duty to engage the public and make sure that they are aware of what we are doing. So with that, I'm going to, let's do public comment first.
All right, we have two speakers. We'll set the timer at 3 minutes.
Thank you.
Our first speaker is Scott Largent. I'm unmuting you. Please accept the unmute. You'll have 3 minutes to speak. The timer will start when you begin speaking.
Thank you. Good afternoon, everyone. Scott Largent. I sure hope Mike's animals are okay. I know he's a big animal person, and I've dealt with that in the past. So I sure hope everything's okay. Mike never misses a meeting, so my thoughts and prayers are with him. That's difficult stuff to go through. What I'm not necessarily complaining about today, I am still being prosecuted by the DA's office and the city attorney of San Jose, and I've been fortunate through the discovery motion for a Murguia motion. I've been getting just an amazing amount of information that is just really showing what kind of happened to my motorhome, my civil rights, and the malicious prosecution out of Howdy Doody's office there, Jeff. What I'm trying to tell everybody is that my motorhome was never properly lien saled. The tow company, which is Courtesy Tow, which owns Motto's Tow, and the dirty dog there is Robert Sandoval. And what he keeps doing now, as he's subpoenaed, we've subpoenaed him 3 different times for records. And I do understand that it's 4 or 5 years down the line of when the motorhome was taken. And I'm fortunate enough to have a sympathetic judge right now that is allowing this to kind of play out. The tow company, I mean, they produced documents that had different dates on them, forged signatures, tracking numbers that didn't exist. So the whole lien sale process, I mean, it just crashed and burned. They've been literally breaking state law. Now, we had this happen about 10 years ago with a lot of tow companies here, and our DA's office went after them. And it just doesn't look like we're doing that anymore. Now, this tow company has been doing this to the homeless community for over 40 years. And they keep renewing that city contract every 5 years. I was able to basically track where Robert Sandoval is donating his money, what campaigns, what committees, what nonprofits, and how he basically stays in business. It's very, very sad. I would hope that the DA would, go after the real criminals in our community. And instead, he keeps coming after me for standing up for my humanity on a sidewalk, basically begging him to enforce the law and figure out where my property's at. Now, I'm not going to give up on this stuff, and some of it's out of the statute of limitation, but these are companies that we should not be dealing with in Santa Clara County. And the information's there, and Jeff Rosen has the opportunity to protect the homeless community. And I highly doubt that he'll do it. So it is what it is. So thank you.
Our next speaker is Susan Bassey. I am unmuting you. Please accept the unmute. You will have 3 minutes to speak. The timer will start when you begin speaking.
Yes, good afternoon. Can you hear me?
Yes.
My name is Susan Bassey, and all of you are familiar with my work. And this county has a pattern and practice of severe civil rights and human rights violations that really deserve the attention of the federal government. But more recently, in a complaint that Judge Zahner is very aware of, and a complaint that was brought to the county whistleblower program back in 2018, where your Public Safety and Justice Committee member, Matthew Fisk, was fully aware of this complaint, is the fact that over the last 20 years, the courts have developed a custom and practice of appointing attorneys to act as judges, meaning we are delegating the responsibility of publicly paid judges to private attorneys. And we are either asking the county to pay those fees for those judges who are essentially imposter judges, or we are asking private families to pay these fees. The issue is that the law is very clear that when these cases are moved from public court to private court, that the court has a responsibility of publicly posting these cases so that anybody in the press or the public could find them, and so that litigants could check the quality of the work of the judges who are appointed in their cases and have an opportunity to object. When I finally obtained these, when I first requested these records in 2016, I faced severe retaliation from Joe Macaluso, the public information officer, who called me a sovereign citizen to my colleagues in the media and tried to discredit me. But his work was not done standing alone. It was done with the assistance of the judges sitting on this committee and others who worked to retaliate against me for asking for the list. When the list was finally produced in 2017, it only reflected less than 5% of the actual cases, meaning the courts were secreting these cases, and who the judges were being appointed in these roles. In 2018, Sharon Roper again posted another list and then another. And when I found the cases manually, her list began to grow, and it is now on the public website for the court. Access to the courts is one of the most fundamental rights in our society. These private judging appointments show that 100% of the private judges being used are white men specifically, where less than 2% are women. That does not reflect the demographics of this county. It is an injustice, and it has imposed racial and gender bias in all of our court cases. The court managers know, the supervisors of the county know, and the county executive, Jeff Smith, and the county counsel, James Williams, know. This is racism, this is gender bias, and all your women's policies and committees had never detected it. You are engaged in conduct that is contrary to public policy, and you are using public funds for racist white supremacy.
And that concludes our public speakers.
Thanks, Dave. Approval of the consent calendar requires a quorum. So the minutes of our last meeting will be forwarded to the next PSJC meeting for approval, and item 13 will be held in its regular order. So that brings us right now to item 4, which is to receive verbal reports from departments reporting to the Public Safety and Justice Committee relating to the COVID-19 response. And Martha, is Martha organizing that, or someone else?
Actually, this is Gary Hersig,
Gary.
Deputy County Executive, taking over for Martha as she moves on to a new assignment. Just as a reminder, at the last meeting, Supervisor, you requested additional information from the departments on plan changes as health guidelines start to ease, as well as what services that were suspended are going to come back online, and additionally, what changes going forward that we learned from COVID that we will keep in place. So we've put that out to the departments and asked them to report on that today. So we'll go ahead and start with Superior Court and Judge Zahner.
Thank you, Gary, and it's good to see you back on the committee. Look forward to working with you in the future. And as I complimented privately in email, welcome back from the EOC and all the good work you've been doing there.
Thank you, Judge.
I wanted to start by actually thanking Gary and Martha and Miguel Marquez and Dr. Hahn and all of those on the vaccine crew that enabled our courts employees and judicial officers access to the public safety vaccine clinic during its last 2 weeks. That was very reassuring to all of us to keep all of us safe in our interactions with the public, and to move forward as we all are looking forward to toward a different reality as we move toward the end of this long pandemic. We as a court are, as you know, beholden to the budget from the state. So we are anxiously awaiting word from the governor's office on the May revise to the budget, and making cautious plans for reopening more court services, more departments, more courtrooms to the extent that our budgetary allotment will allow. The budget controls more of what we can do in a sense than COVID. COVID and health regulations will affect our manner of delivering services, numbers of people we can bring in, numbers of jurors and things of that sort. We had a supervising judges meeting yesterday. We have an executive committee meeting next week, and we're making tentative plans based upon what we hope will be some restoration of the severe budget cuts that have devastated our court this last year, where, as you probably all know, we lost 20% of our court staff, and that has severely constrained our ability to deliver the services to the public that we want to deliver and the public expects and deserves from the courts. So I can't give you the concrete plans yet as to what we are going to be doing, because it is so beholden to the budget. but we are making those tentative plans as we go forward. We hope to open additional departments, to have additional trial departments going, to keep the clerk's offices open as we have reopened them and opened them longer hours for access to the public, and continue to enable services such as live chat and other online interactions with our clerk's offices and our self-help office, which we found has been very helpful and much used by the public during this time. And of course, as we all are, we're keeping a close look on the public health orders from the state and from the county. We're looking forward to how those may change to know how we can safely enable further and greater access in terms of members of the public actually coming into our courts. The biggest learning, I'll just finish with this, from the pandemic is that we have so kickstarted our ability to provide remote services, remote hearings, and I anticipate that will continue going forward. That has been a benefit, if you will, of our having to rapidly pivot toward a different method of delivering services, or at least providing the option to do that. Thank you.
Thank you. Thanks, Judge Zaner. Did any of the committee members have any questions for Judge Zaner? If not, we'll move on. Thank you very much.
All right, let's move on to the district attorney's office.
Good afternoon. Let me address the three areas that Supervisor Ellenberg had wanted addressed from the last Public Safety and Justice meeting. First, as the public health guidelines ease, we're looking forward to the courts increasing the number of courtrooms open for criminal cases and increasing the ability for victims, defendants, and witnesses to have these cases go to trial. Last year, we tried 60 jury trials, which was an amazing number during the pandemic, but dramatically fewer than the more than 200 trials we do in a typical year. For our office, while we've been working remotely in lots of ways and appearing remotely in court hearings that don't require witness testimony, we have continued to provide in-person victim services and in-person court advocacy where hearings could not be done remotely throughout the pandemic. We are also, like all departments in the county, looking forward to our disaster service worker heroes coming back from their critical work at vaccination clinics to alleviate the strain on those left behind. We've had more than a third of our staff, of our support staff, reassigned as disaster service workers, and we're looking forward to them coming back. It's caused additional burdens on our department. Number two, in terms of things that we didn't do because of COVID, well, we didn't suspend any programs because of COVID. We continued to file cases in criminal court, to divert cases from court, to address gun violence, sexual assault, domestic violence, and more. We continue to provide both remote and in-person services for victims of violent crime, including accompanying victims to court when their in-person testimony was needed. We didn't let the pandemic slow us down in opening the Child Advocacy Center, and I know many of the people at on this meeting were at the opening of the center a couple weeks ago. Nor did we let COVID slow us down in terms of launching a strangulation pilot for the county, or in doing pandemic-related work, like our work to address the needed reduction of our jail population for the safety of both the inmates, the staff, and the greater community. Number three, we have accelerated our transition to becoming a completely paperless office, with more than 85% of our cases being prosecuted without ever creating a paper file. That acceleration will not slow, and we expect to be 100% paperless by the end of the calendar year. We also hope that we will be able to find more ways in the future to allow victims to watch and participate in some court hearings where they want to attend remotely instead of in person, and where their in-person attendance is not required, just as they've been allowed to do during the pandemic. Thank you.
Thank you very much, and kudos once again on opening the Children's Advocacy Center. It really would be quite a feat in regular times, and to have done it over this past year is really nothing short of remarkable. Thank you. Also impressed to hear about going paperless and looking at Dr. Smith's screen. It's something that I've been trying to encourage for the Board of Supervisors. We get a lot of paper in memos, especially confidential memos and board materials every week. And I think it would be a great goal for us to match the district attorney's office.
Well, I just want to say in full disclosure, I had notes on paper for the remarks that I just gave. So maybe in 6 months, I'll just be able to have the notes on my phone.
It's all a journey. It's all a journey, but I think that's a very commendable effort. Thank you very much. Does anyone have questions for the district attorney? All right, back to you, Gary.
All right, let's go to Sheriff Smith, please.
I should have given this. Okay, sorry, sometimes our system is a little bit slow. So in terms of what we've been doing and what we continue to do, we have been fully functional during all of the COVID times. Our people have been coming to work, and I'm really proud of each and every one of them. At the last meeting, we talked a lot about that. So for this meeting, what I'd like to cover is some update from Sergeant Menchaca. And then some of the programs that we had not been doing are programs within the jail. And we'll have Captain Duran talk about some of those programs. So if I can first introduce Sergeant Menchaca.
Greetings, Supervisor Ellenberg. The Sheriff's Office currently has 2 staff members and 1 inmate in isolation with COVID-19. Our Custody Bureau staff, who are mandated to test daily, are averaging 100% compliance. And as far as vaccine statistics, 64% of all Sheriff's Office staff have been vaccinated. And to be specific to the Custody Bureau, 58% of our custody sworn staff and 73% of our custody civilian staff have been vaccinated. This is an increase from the report I presented on April 8th of 6% to our custody sworn staff and 9% to our custody civilian staff. And that concludes my report.
If there are no questions, perhaps we can go to Captain Duran.
Let's do it. Thank you.
Excellent. Good afternoon. Early on during the COVID pandemic, we halted many of the in-person structured programs. In the fall of 2020, the Sheriff's Office looked to create new ways to bring back structured programming opportunities to the facilities. In the fall of 2020, we created a virtual pilot program, which allowed us to bring structured programs back into the facilities. Our program partners were able to provide the classes from offsite locations remotely to various housing units by connecting televisions and laptops with webcams. So currently, using that virtual platform, we're currently offering approximately 30 unduplicated courses that rotate every 12 weeks. This also allows us to provide programs and presentations throughout our facilities. This also gives us the ability to ensure the safety of staff, program participants, and the program providers while adhering to public health recommendations. One of the things we also were able to do was start a hybrid pilot. The hybrid pilot basically consists of both in-person classes and remote classes when needed. So we've partnered with City Lab professionals to bring in the Cisco Network Academy. This academy is currently providing services both remotely and in person for those participants in custody as well as those in alternative sentencing. The Cisco Pathway is a 12-week in-custody course. Every 12 weeks, new participants are given the opportunity to participate, both male and female. It also offers certification for train the trainers. Teaching assistants will be able to assist with future classes in custody. Cisco is also providing job placement and housing to participants upon their release. Some changes to services and what we hope to do in the future is to continue with remote programming, to continue with remote learning and transition to a hybrid rehabilitation programming system. The hybrid system will allow us to bring program partners back in the facilities and provide in-person instruction while also still allowing us to bring services using remote services. What we would like to do is begin transitioning the providers we're currently working with using the remote system and start building a platform where it's a hybrid system, which allows all of the programs we're currently using to transition to the hybrid system, allowing for both in-person and remote learning. We also have vocational opportunities. The Sheriff's Office has been working with local community colleges to bring in vocational services to our facilities. This spring, we'll be starting some of the vocational classes. Spring was chosen because that aligns with the City College's class schedules. So participants will be enrolled in city colleges and may continue the courses when released at any city college, and also may transfer college credits to the college of their choice. These providers will teach classes in person and also remotely as well if needed. Some of the vocational classes that we will be providing include multimedia, welding, automotive, kitchen management, and culinary. And then for early 2020, those same colleges that we're working with also plan on bringing in HVAC, electrical, plumbing, and construction. So one of the things that we're doing is we're making sure that the recruitment for all of our programs are ongoing. Our rehabilitation officers are going out to all of the housing units and recruiting individuals who want to participate in any of the programs that we offer. And they're all on 12-week rotating schedules. So that concludes my report, and I'm available if there's any questions.
Thank you very much. I don't have questions. Do any other committee members? It's a lot of exciting options. Thank you.
Thank you.
All right, let's move to custody health services.
Good afternoon, Supervisor, and this is from Custody Health. And part of with the resumption of services, Custody Health Services has continued to provide medical, mental health, and dental care during the COVID pandemic. We have moving from non-contact groups to more face-to-face groups with our clinicians. And so we're pulling patients out to do groups, and we're providing that physical distancing as described by our public health. I need to apologize. I do have some construction going on behind me. So I'm trying to talk with construction. We're also continuing our very aggressive activities around COVID-19. We're providing the vaccinations now with our patients, trying to get to that herd immunity. So we are working also with our custody bureau to begin having some of our stakeholders like behavioral health, the STEP and AB 1810 stakeholders to come in and work with our patients. And so overall, we're providing that urgent, emergent, and routine care across medical, mental health, and dental, and beginning to do more in-face contact groups. Sorry about that. That's all I have.
Thanks, Dr. Day. Are there any questions? Gary.
All right, let's go to the Public Defender's Office. Molly?
Thanks, Gary, and welcome back. Good afternoon, everybody. I'm going to try and be a little brief since we have a lot of great presentations coming up, including from our office. In terms of reopening and things we're going to go back to doing that we did before, one area we're really looking at is bringing our paralegal staff back in to do in-person interviews, both at the jail and at the office. We really feel like that first contact is important to be done in person. So we're getting some additional PPEs, including plexiglass dividers for in-person interviews at our office, a cleaning protocol to wipe down between interview sessions and that kind of thing, as well as talking to the bargaining units about what the timeline is and what that will look like exactly. We're having a lot of internal conversation, as I'm sure the rest of you are, about how to continue to telework effectively and kind of reintegrate, but keep the impact to the environment and keep what's been working well. Our investigators, for example, do a lot of in-field work out of the office anyway, even in normal times. So it may make sense to have many of them continue to work remotely. So that conversation is going on an almost daily basis. We will certainly continue to use remote video interviews because it turns out we can we can see more clients more regularly without a lot of wait time, which because just by the nature of the jail, things happen at the jail and we end up waiting around for 2 hours. So we hope to do that. The other added advantage to video interviews with our clients is that we can have more than one person talking to the client. So if we need our social worker to talk to the client, we can do that very efficiently and effectively remotely. So we will definitely continue doing that. And then I just had two things. I would say roughly 90 to 95% of our staff of 280-ish are vaccinated, and that's terrific. We're trying to do our best to help with herd immunity. And finally, just in response to Judge Zahner's comments related to budget, I realize the court has been impacted tremendously, and they're working really hard to make do with what they have and reopen courtrooms wherever possible. I would just put in a pitch again to prioritize reopening South County and North County courthouses so that those client populations don't have to travel all the way to San Jose as traffic picks up. And even without a lot of traffic, it's very difficult for many of those folks to come from Palo Alto or Gilroy or Morgan Hill all the way to San Jose, and they miss court dates as a result. And it's just not fair. So I hope the court is able to find a way in that area. And I'm happy to answer any questions if there are any. Thank you.
Thanks, Molly. That was something that I heard from folks when I spent a morning at the Hall of Justice, that there were people that showed up for calendar, and because of the crowding, I know it was an unusual situation, but their hearing dates were changed. And of course, they had taken off of work or had to arrange childcare. So I would really support a process going forward that eliminates that need for people to spend so much time, most especially if they're going to be bumped in the calendar. So thank you for that. Any questions for the public defender? Thank you.
All right, let's go to the Independent Defense Counsel, Sylvia.
Hi, everyone. Since IDO remained completely operational during this entire period, I'm going to focus on just a couple of things that are going to be noticeable improvements in our work. One of them, a big project we were working on with the court for a long time, even prior to COVID, was the opening of Odyssey to provide attorneys both IDO and private access to the court files, certain limited access, but nonetheless significant access, both because it was going to be environmentally friendly and paperless, but also because it was going to create an important efficiency, particularly for the appointed attorneys, many of whom had to rely on support staff to stand in line for hours or return multiple times, costing the county significant funding for those errands. So luckily, we were able to, in great collaboration with the court and with the significant contribution and support from Supervising Judge Eric Giffon, we were able to do that. And so now that is completely operational, and we were able to provide some support to the Superior Court IT staff by creating a committee wherein we provided some support and intersect between the private bar and IDO and the Superior Court IT team. So we are very grateful for that, and that's been accomplished, and we think that will have a significant contribution and create significant impact, including savings and time to the DA's office that often has to provide that information because it's not otherwise available. The other important thing was that IDO was an important player in providing access to the courts, to litigants in the criminal division. We collaborated with the court IT in providing links to the public, litigants, both attorneys and private and appointed, and others. And we will continue to do that. And as Judge Zahner indicated, that if that is maintained and incorporated, we will continue to be a partner in that. And that is thanks to our great support staff. And another significant improvement that we did, again, the PD's office innovated it, but the use of our tablets for Zoom communication with attorneys. That was an important added resource to our staff and our attorneys, because that is going to maximize the quality of communication that they have and provide another opportunity to do that. We hope that that will create an efficiency that is going to be demonstrated both in resolutions as well as just advancing the cases forward once we're fully operational in the courts. So that is my report. Thank you.
Thanks, Sylvia. Does anyone have questions?
All right, let's go to probation. Laura?
Thank you, Gary. Good afternoon, Supervisor Ellenberg and members of the committee. So since the last time we spoke, a few things have happened. In Juvenile Hall and the ranch, we're doing visiting every weekend. That's going really, really well. We're doing outside visiting with families. School's back in session in full swing, so that's also great. Behavioral health is coming into both institutions, also great news. At the current time, as far as out of the programming coming into the institutions, we're collecting vaccine, verifying vaccines, and once verified, they'll be allowed in. So we're in the process of that. So that's very, very soon. That's about it on the juvenile side. On the adults, and you know, much like the sheriff's office, our staff have worked much harder this year than they have in most years in the institution. So just kind of an update. On the adult side, we have many of our disaster workers are returning, which is just great news because we had a lot of our staff have been doing just extraordinary disaster work. Many of them have been able to return. As such, we've re-implemented a few things like fingerprinting and increased testing and increased contacts. So we were happy to have them help the county and super happy to have them back. Also remaining focused on domestic violence and sex offenses and our highest risk clients for contacts. We're launching a new case management system that hopefully will make everybody's life much easier, and that's taking a lot of our focus. And just one example of what we will keep, I've mentioned some other things before, but one example that I think is a really good example is we run a victim awareness class where victims come in and talk to youth, and not necessarily their victims, but victims of other crimes. And that seems to, from all everybody involved, seems to be having a much better impact remotely, with people having being more comfortable disclosing and more comfortable expressing empathy. So we'll at least keep part of that. So with that, I'm happy to answer any questions.
Is the victim awareness program something new?
No, it's not. It's something we've run for many years in concert with the district attorney's office.
Thank you. Any other questions for Chief Garnett? Thank you.
All right, let's move to reentry services. Javier?
Good afternoon, Supervisor Allenberg. So what are the reentry center's plans to address changes in services as public health guidelines ease? So in terms of educational programs, we're excited that our newer high school diploma program through the County Office of Ed will be able to utilize the computer literacy lab as originally planned. They're at the Reentry Center in San Jose. We're also going to be bringing back the San Jose City College peer mentor classes in the fall. Probation will be again present at the South County Reentry Center and also at the San Jose Reentry Center. We're also looking at increasing capacity at the Sobering Mental Health Drug Triage Center. Currently, they're at 10 recliners, but there can be up to 20 recliners. So we're looking at increasing that capacity. And then in terms of programs that can be brought back after suspended due to COVID, most of all the programs through the sheriff will be resuming back at the Reentry Center. Our outreach court with Superior Court will resume at the Reentry Center. And then we've already resumed in-person police briefings, letting the police officers know about the Sobering Center and reentry services. So we did 12 of those briefings last week. They're at the San Jose Police Department. And then in terms of services changed during COVID that we will maintain, in collaboration with the sheriff's program staff and Captain Duran and his staff, we will promote the hybrid model with all of our providers that provide services in custody, so do both in-person and virtual presentations. We've started doing virtual presentations about just reentry in general, and that has worked out well. We started with the women side of Elmwood, and the women were very engaged in terms of asking questions, even through video conferencing. We're going to maintain our phone and virtual intake, registration, and triage, so folks have options to call and receive the intake and registration via phone, and also we're offering them to also do it through a Zoom. And then our lived experience advisory board, we used to meet, well, we still meet quarterly in person, but a lot of folks like the idea of the virtual, since many are going back and forth between work and home. So we're going to continue doing that. And then lastly, we started doing an extended hours on Tuesdays and Thursdays from 5 to 8 p.m. and the first Saturday of the month from 8 to 12. So we're going to continue doing that. And most importantly, this week, public benefits, social service agency will start with that service. So not only will it be Office of Reentry Service staff, but also social services staff there to provide information about public benefits, as that being our top request from our clients. Thank you.
Thanks, Amir. That's really exciting work. I want to acknowledge Supervisor Wasserman has joined us. Dave, does that mean you need to take a formal roll call again to establish the presence of a quorum?
If I may, yes, Madam Chair.
Please do.
Vice Chairperson Wasserman.
Here.
And Chairperson Ellenberg.
I'm here.
Thank you. A quorum is now present.
Thank you very much. So when item 4 is finished, we'll go back to the consent calendar. Gary,
Right.
back to you.
Thank you. Let's move on to pretrial services. Matt.
Thank you. Good afternoon, Supervisor Ellenberg and all. I'll make my comments very brief. We're grateful to be able to provide all services at this time other than drug testing, which we hope to resume with the fiscal year. We would start with the Prop 36 drug testing as a priority, and then resume with the pretrial drug testing. Everything else we're able to do at this point. And what that looks like is we have about 2,700 individuals that we supervise out of custody. And as a standard of care, we have a weekly contact. So we have over 10,000 contacts per month with our clients. And just to break it down real quickly, that's 808 people on electronic monitoring, 836 people with the pretrial application. We correspond back and forth by phone and text. There are 100 diversion clients, 50 of which are incompetent to stand trial. And then I'm glad to say we've increased our interaction with reentry services. We have 638 people connected to reentry services, and they're providing tremendous support. Also, I'd like to thank probation. They've given us so much support during this time. We've done a lot of work. We share 200 or 300 clients, and they've just been nothing but supportive of us. We'll be providing some training to the bench next week. We hope to have 50 or 60 judges there, Judge Daner. And I'd just like to take one moment to share one thing that we're doing different. And I'll just give you a quick detail on a release we did. This is really a thanks to the Sheriff's Department. They helped to expedite a release and admin booking and behavioral health. We had a peer mentor worker who picked up a client. This is something we just started doing. We're starting very small as we build capacity. They picked up a client who really needed a lot of support, transported the client to pretrial services where we put the ankle bracelet on. And then the detail that we got was the client was taken back to reentry services, got a substance dependence and mental health assessment, ID voucher, didn't need clothing or food, but the mobile medical unit was there, helped him pick up his medications, connected him with social services for SNAP, cash, and medical aid. As he didn't need placement after the assessments, his sister picked him up, and he'll receive ongoing support from reentry services and pretrial. So glad to say that we're able to do that. I can only do that as a team. That's my report.
Thanks very much, Matt. Appreciate hearing that. Any questions for pretrial services? Okay,
That concludes the report,
That's it.
Supervisor.
Very good. Thank you very much. And Gary, welcome to you. There's no action that needs to be taken. That was to receive reports. So I'm going to return now. We need to do public comment on item 4, please, before I move on.
We have currently 2 speakers on this item, Madam Chair.
All right, let's do 2 minutes, please.
Okay, one moment while we get the timer up, please. Our first speaker is Scott Largent. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Thank you. You know, just hearing what Matt had to say just now, Matthew Fisk from Pretrial Services, really put a big smile on my face right now. I mean, this is really neat to hear. That's success right there. And the fact that we could get somebody these services and get a hold of their family member and kind of get them on their way is fantastic. I say it over and over again, what I had to deal with 5 years ago, and it was literally wrapping myself up in a gardening tarp and sleeping on top of the toilet in the sheriff's bathroom over there to stay warm. I mean, it was rough. It was difficult. Family didn't want me calling them. There was no way of getting out of any of this stuff. Having people prepared and waiting when somebody gets out of jail to hold their hand to do a lot of this stuff prevents them from making that left-hand turn down, heading down to basically Lord of the Flies. I try to do my part down here, and I basically wave that flag and tell people, look, you don't want to be here. You need to go the other direction. You need to, I give them a roadmap in a way. But this is great news, and I just hope we can do this for as many people as possible. And I really, really worry about vulnerable women that are being released from the jail. I told you guys that story about the gal that came and started knocking on the side of the van, and it was just really, really sad, some of the things that she was saying to me. And you know, I was trying to warn her where she was at. She was trying to get back to San Francisco, and you know, it was just really sad. And I think now this can be avoided. So fantastic work, Matt, and good job with the Sheriff's Department working with you on that. It just sounds like people really are listening. I really, really, really do appreciate hearing this. Thank you.
Our next speaker is Susan Bassey. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Yes, I would like to comment on the issues that were just presented about the status in our county and access to the courts. It was complete misinformation on all of our elected and public employees' part. Judge Zahner, you know that the courts are not functioning and assuring equal access to the courts, and we're all entitled to equal protection under the law. The fact is that attorneys are being given access to our courts that are not being given to self-represented litigants. The court public access lines are not functioning, and you know that because I have made multiple complaints and have had others make them as well. People are being denied due process, and you are all trying to pretend like it's all been working. It has not been working. It has not worked. It has not functioned, and it is not functioning the way you are informing the public that it is functioning. Jeff Rosen is the most corrupt DA that we have ever had in Santa Clara County. He has sheltered in place in his office and hidden like a little scaredy cat as far as going into the courts himself. His prosecutors are not going into the courts, and they're dropping off court lines when victims are speaking or when there is important information being given to the judge. Meanwhile, the IDO and the public defense attorneys have to go into the jails where there are COVID outbreaks, and they also have to go to court to make personal appearances, and they are fighting very hard for their clients in very difficult situations. The judges are checked out about what people are really going through, and the mental health issues in this community are growing to a point where it is a serious matter of public safety. You are not talking about that, and you are just making yourselves feel good about the information that you're giving at these meetings. You need to start getting more community input. You need to start listening. You need to have a complaint process. You need to address the violations of due process when courtrooms are closed or public access lines are not working. And you also need to address.
That concludes our public speakers.
Thank you very much. We'll return now to item 3, which is approval of the consent calendar. And now that we have a quorum, I would like to recommend that we add item 8 to the consent calendar. This is the semi-annual report from the Office of Gender-Based Violence. And additionally, I'd like to request that a joint report from OGBV, probation, and the courts be presented at a future committee meeting regarding the status of batterer intervention programs in the county and current efforts to develop more successful programs. And just to flag what's coming later, I would like to take items 9 and 10 together. Those are the 2 custody health reports. So Supervisor Wasserman, if you are amenable to make a motion, we would approve the consent calendar with item 8 added. We already have 12 and 13 on, and incorporating the request for a report back from the Office of Gender-Based Violence.
Sounds like you made a fine motion. Happy to second it.
Thank you very much. Dave, will you do a roll call for us, please?
Vice Chairperson Wasserman.
Yes.
Chairperson Ellenberg.
Yes.
Thank you.
Thank you very much. So we will move on to item number 5, which is to receive a report from the Office of the District Attorney related to gang prosecution.
Thank you very much, Supervisor Ellenberg and Supervisor Wasserman. I have with me at the meeting Stacy Capps, who's from our executive management team and oversees a number of teams in the office, including juvenile and gangs. And also present is David Pandori, who's the direct supervisor of the gang team. And they prepared and I reviewed the semi-annual gang report. I think this is the first time that we've presented this report. I think in the past it was produced by the Sheriff's Office. And so with that, I'll turn it over to Stacy. It's very detailed and she'll give you kind of a summary of it. There's a lot of information there, and then we're happy to answer questions about it. Stacy?
Thank you, Jeff. Can everybody see that?
Nope.
I actually logged on early and tested this out, so I'm sorry.
Stacy, we have it if you are having issues with it.
I'm sorry, I don't know what's going on.
Do you want Dave to share the screen and
That
share
would be
your
great.
slides?
That would be great.
Okay, one moment while we pull that up. Let's go full page. Oh, where is it? I'll do it this way. Okay.
There you go.
Great. Okay, so at the Santa Clara County District Attorney's Office in the gang unit, we prosecute felony cases committed by gang members. We prosecute felony cases that are gang motivated, crimes that are committed for either the benefit of a criminal street gang or in association with members of a criminal street gang or at the direction of a criminal street gang. It is not a crime to be a gang member, and we never prosecute somebody just for being a gang member. Prosecutions require a gang member to associate in association to commit a crime. Gang enhancements require proof that the crime was committed for the benefit of, in association with, or directed by a criminal street gang. Recently, and Bend the Arm implemented in our office, Jeff Rosen decided that despite the fact that current state law permits a district attorney to charge a gang enhancement on misdemeanor crimes, which would convert that misdemeanor to a felony, that he would no longer charge the gang enhancement on misdemeanor crimes unless there was a public need to do so. Common gang-related misdemeanor crimes are fighting in public, simple assault and battery, vandalism, graffiti, carrying a concealed fixed blade knife or switchblade, brandishing a knife. And at this time, we will not be charging the gang enhancement on misdemeanors unless there is an extenuating and extraordinary public safety concern. This office pursues appropriate punishment for the misdemeanor crime without the gang enhancement, considering both mitigating and aggravating factors. Common gang-related felony crimes that we prosecute at the DA's office are murders, attempted murders, felony assaults, drive-by shootings, attacks resulting in great bodily injury, death threats, threats of great bodily harm, witness intimidation and retaliation, robberies, carjackings, extortion, and jail assaults. Here's a summary of the current cases being prosecuted by the gang unit. It's currently prosecuting 345 gang-related cases involving approximately 432 defendants. Of the 345 gang-related cases, gang enhancements have been charged in only about 52% of the cases, which clearly shows that the DA's office is using both their discretion to really focus on individual assessments of each defendant and whether or not the gang enhancement should be charged. Gang enhancements are only charged when there is evidence that the crime was committed for the benefit of, in association with, or at the direction of a criminal street gang. Gang-related cases in 2019 versus 2020. In 2019, we had 215 cases referred to the Santa Clara County DA's gang unit. In 2020, during COVID, we had 335 cases. So that was a little concerning and quite a bit of a drastic uptick in our gang cases that were being brought over to the DA's office. The Santa Clara County DA gang unit is currently prosecuting cases involving approximately 40 murder victims and 68 defendants for those murders. Obviously, in many of our gang cases, there's more than one defendant involved, both in juvenile and in adult. We are currently prosecuting 69 attempted murder, prosecuting cases involving 69 attempted murder victims and 161 defendants. Currently, we're prosecuting 92 separate victims of gang-related felony assaults, 33 different buildings or vehicles shot at during gang-related drive-by shootings, and 51 separate gang-related robbery victims. We're currently prosecuting cases involving approximately 19 victims of gang-related witness intimidation and 12 victims of gang-related death threats or threats of great bodily injury, and 28 victims of gang-related burglaries. Currently, we're prosecuting gang-related cases involving 43 separate victims who have suffered great bodily injury during the commission of the crime. The underlying crimes are primarily attempted murders, felonies, assaults, and robberies. We also prosecute a number of jail crimes involving gang members. Gang structures exist and operate in the local county jail population, as well as the juvenile facilities. Gang-related crimes in the jail include crimes between rival gang members, but more often are committed against fellow gang members who are considered to be in bad standing or refuse to participate in criminal activity in the jail. Commission of jail assaults often involve the use of weapons. Commission of gang-related jail assaults are sometimes facilitated by illegal covert communications, commonly known as kites. Our office prosecutes cases involving weapons and illegal communication in addition to assaults. Many of the jail crimes, jail assaults, are also committed by multiple inmates. The DA's gang unit is currently prosecuting approximately 20 separate gang-related jail assault cases involving approximately 90 inmates. The sheriff's office does not refer all jail assaults to the DA's office for prosecution. Some cases are handled administratively and others remain under investigation. The sheriff's office can provide more complete information on the extent of violence in the jails. Little hiccup here on this slide, you see it's 19 cases and 60 inmates. We just recently received an indictment on a jail assault case. We'll be doing a press release probably next week, but it was a number of inmates involved in that case. Let's talk about some gun crimes related to gang participation. Common gang-related firearm crimes. Carrying a concealed loaded firearm on the person or in a vehicle, driving with a loaded gun that is unregistered or stolen or for the purpose of committing a crime, possession of firearms by felons or by unauthorized persons, possession of assault weapons, or using a firearm during the crime. It is not unlawful for a gang member to possess a firearm. Excuse me. It is unlawful for a gang member to possess a firearm if the gang member is convicted of a felon, is a convicted felon, or convicted of other specified crimes, possesses the gun for the purposes of committing a felony, if the gun is concealed on their person, loaded, and unregistered, if the gun is transported in a vehicle loaded and or unregistered. There's a growing occurrence throughout the nation of what's called ghost guns. Ghost guns are guns that are 80% complete when bought and do not have a serial number. The buyer purchases a kit with additional components and tools to assemble the combined parts to create a fully working firearm. The benefit to criminals is that these firearms escape registration and can get into the hands of persons who are not permitted to possess a firearm. In 2019, the state enacted AB 879 to permit the sale of precursor parts only by licensed dealers. AB 879 was originally slated to take effect in July of 2025, but the date was advanced to July of 2022 under SB 118. We also deal with large capacity magazines. Patrol officers are frequently finding gang members and associates with large capacity magazines in the field. These are magazines with a capacity greater than the normal 10 rounds. State law prohibiting the possession of large capacity magazines has been stayed from enforcement. In 2016, the legislature enacted SB 1446, which prohibited the possession of these large capacity magazines. The ban was to take effect in July of 2017. However, Proposition 1363, enacted in November of 2016, made possession of LCMs a misdemeanor. 2 days before the LCM ban was to take effect, the U.S. District Court for the Southern District of California issued a preliminary injunction enjoining enforcement of the law. The U.S. District Court held the ban was unconstitutional under the Second Amendment, and the case was appealed. In August 2020, a 3-judge panel of the Ninth Circuit Court of Appeals affirmed and held that the law was unconstitutional under the Second Amendment. In February 2021, the Ninth Circuit vacated the 3-judge panel decision. The constitutionality of the prohibition of LCMs now will be decided en banc by the Ninth Circuit. Prosecution of LCM cases is enjoined pending the decision of the Ninth Circuit. Currently, the Santa Clara County DA Gang Unit is prosecuting approximately 160 gang-related firearm possession cases. Most of these cases involve the recovery of loaded firearms during vehicle stops. Here are some examples of focused efforts on firearm reduction in our community that we've made in the last year. In April and May of 2020, a rap video filmed during COVID restrictions showed a large number of gang members associating together and displaying and brandishing firearms, including assault weapons in a public park here in San Jose. San Jose PD began a proactive effort to find these illegal weapons and take them off the streets. The DA's office assisted on many search warrants. The effort led to the arrest of 8 suspects and the recovery of 6 firearms taken off the streets. In February of 2021, San Jose PD identified a variety of separate crimes that had been committed by a single criminal street gang. The DA's Crime Strategies Unit worked very closely with the gang unit and San Jose PD and assisted them with the identification of these cases that were connected together and search warrants. The effort led to the arrest of 11 adults and the filing of approximately 13 separate cases involving firearms, robberies, shootings, and gun possessions by gang members with prior felonies. The gang unit is currently prosecuting cases involving approximately 105 separate victims in gun-related crimes. These are crimes where a gun was either used in the commission of the crime, a gun was fired, or a victim suffered great bodily injury or was killed with a gun. So that is the PowerPoint presentation. And I'm happy to answer any questions. But I do want to just comment that we really are trying to focus at the DA's office on those violent crimes that are being committed in our really vulnerable communities. And our focus has been more so on those crimes. Unfortunately, there has been an uptick in that amount of violent crime we are seeing. Thank you so much.
Thank you. Thank you both to the district attorney and to ADA Stacy Capps for the report. I don't know if we have too many people off of mute or if that was
You're
me
good now.
with the feedback. Okay. I appreciated the clarification regarding when a gang enhancement can be charged. And I understand your department's commitment is not to seek gang enhancements in misdemeanor crimes unless they involve, quote, an extraordinary public safety concern. Could you offer an example of what would constitute an extraordinary public safety concern that's still a misdemeanor?
Yeah, so if we have an incident where somebody has brandished a firearm and or maybe discharged a firearm, and we feel that based on the history of that particular person and the particular circumstances of that crime, that it does create a public safety concern, we might decide to file an enhancement on that misdemeanor crime. But I do want you to know that each one of those decisions is going to be made by both myself and the supervisor of the gang unit. It's not something that the supervisor will be making that decision alone. I will also be weighing in on that decision.
So it sounds like it's really case by case, not a list of
Absolutely
actions.
Absolutely. It is definitely a case by case analysis.
Got it. I appreciate that. In recent years, we've seen groups like the Lash Money Gang that receive the gang moniker, even though they're not really a traditional gang organization, as I understand it. They organize over the internet, come together for the purpose of committing a crime, and then disband. Given that and more things happening through the internet, how do you define gang?
Well, the gang definition has not changed. It's a group of 3 or more people with a common goal, a common symbol. We still have to meet all of those requirements. The difference now that we're finding is that these individuals still consider themselves to be a gang. The way that they're coming together is different, and perhaps their motivation is different. We traditionally saw gangs that were very territorial, and they were having conflict over territories or being part of one side or the other. These newer gangs tend to be coming together to commit violent property offenses, carjackings and robberies. And they're coming together from different areas of both our county and other counties, but they still consider themselves to be a gang. They give themselves names, they give themselves a common identifying color. It's not always a color, but certain common identifying things. And so we still have to meet that definition.
Thank you. And I'm sure you'll agree, one of the significant concerns around gang enhancement charges is, of course, the disproportionate impact on minority groups, particularly Black and brown boys and men. Does the DA's office track the racial identity of individuals that are charged with gang enhancements?
I think that is something that we're starting to do. I don't think it's something that we've done in the past. And I also am very interested in tracking the victim's ethnicity as well, because as you know, the people who are traditionally targeted by gang crime are people of color as well. So they're the people who live in those communities, and there are also other gang members who are associating or just living in those communities. So I think it's important to track both.
Yeah, I agree. I think that's fascinating. And I appreciate that you're doing it going forward. What kind of effort would it take if I were to ask the department to report back to the committee with a study that looks at the racial makeup of gang prosecutions over the past 3 years?
The answer to that's probably something we can put together. As you know, Supervisor Ellenberg, every year for the last 5 years as DA, we've published a race and prosecution study, the first DA's office in the country to do something like that, where we track the demographics of individuals that were prosecuting misdemeanors, felonies, and we also break that down by different crime types. One of the reasons that we stopped filing standalone 148 charges, where the only charge was
standalone 148.
Yeah, standalone 148 is a resisting or delaying a peace officer in the performance of their duties. It's a misdemeanor crime. It's a crime that was the most disproportionately charged crime that we had against African Americans. And so that's something that we stopped doing when that was the only crime charge. So when it comes to gang crimes, we should pretty easily be able to put together the demographics of the defendants we're prosecuting. Usually their racial identity is noted by the jail when they're booked into custody. And then in terms of finding the racial identity of the victims of these crimes, usually that is somewhere in the police report, not always, but usually. But I can say based on our experience, what Stacey Capps was saying, which is the demographics of the individuals committing gang crimes in our county is disproportionately African American and Latino, and the victims of those crimes are disproportionately African American and Latino. And the victims of those crimes, some of those victims are themselves gang members. Many of those victims are not, are simply hardworking, nice people that are living in a community being terrorized by members of these criminal street gangs. But we can certainly provide those kinds of demographics over the last few years, and I'm sure that they will be disproportionately African American and Latino. That's what the nature of the gang issue is in our county, as it is everywhere else in California and the nation.
I don't know how the money attaches to prosecutions, but is there additional resources required to be spent in prosecuting a case where there's a gang enhancement?
I don't believe that's the case. I mean, we have approximately 190 prosecutors, and we prosecute upwards of, well, we used to prosecute about 40,000 cases a year. We've since, over the last several years, diverted more than 10,000 cases a year to, out of the court system. So we're prosecuting maybe somewhere around 30 to 32,000 cases a year. And, whether that case is a straightforward case or a complex case, we prosecute it just the same. So I wouldn't say that wouldn't be able to put a dollar amount on what it costs to prosecute a gang crime, just like I couldn't put a dollar amount on, what it costs a victim or a family or a neighborhood to be terrorized by gang members.
Which makes sense. I just wanted to see if I could separate those. Dr. Smith, I see that your hand is up. Do you want to address something that we've just talked about, or do you want to wait until I finish my line of questioning? Whichever you like is fine.
You asked about the cost.
Yes.
I totally agree with the DA that the prosecution, the cost from the DA's perspective is probably not significantly different. However, Sylvia ends up oftentimes defending in gang prosecutions because there are multiple defendants and there are many conflicts of interest. And so the cost to the independent prosecution is significant, which is why on a fairly routine basis, we have to increase the, excuse me very much, increase the budget for independent defense. Sylvia might want to express a little bit.
Yeah, that's fascinating. Cindy,
Yeah,
Sylvia,
so
can you talk about that?
The nature of the prosecutions, especially in multiple co-defendant gang cases, does involve an incredibly voluminous volume of data, especially in the last 10 years when the advent of cell phones, social networks, and other technological innovations that are now used by law enforcement, including body-worn cameras. So the volume of data, as well as the number of defendants, contribute significantly to costs because they take longer to get processed in the courts, especially in the next few years. It'll be even longer because these are cases that we are not trying. We're not taking to trial because there's no ability to do that. There's no ability to hold the capacity for more than 3 defendants at this time. So all the multiple defendant cases are going to be sort of on hold for a while until we have more availability. So those are sort of the external costs associated with the prosecution that then also obviously relate to the defense, because the prosecution costs then translate into the defense costs that the state, in other words, our county, has an obligation to provide as well. So we probably would be able to quantify if we put it all together. But to support what Dr. Smith is saying, the costs are high if we want to just quantify them on a monetary level.
Thank you, Dr. Smith. And Sylvia, thank you both. That is a really good point, and I hadn't thought of course, the counterbalance that increases in the defense. Yeah, Sylvia, if that's something that your office can put together, increased costs that are associated with gang cases, even just in the last 2 years, I think that would be really interesting to sunshine and share.
I think something that's interesting about that is whether or not a gang enhancement is charged. If we have cases involving multiple defendants, as Dr. Smith pointed out, often IDO will need to be involved, whether or not we've charged a gang enhancement. Because as Stacy pointed out, we don't just charge gang enhancements in every case we can. Of course, 80% of the cases we file are misdemeanors. We almost never file a gang enhancement in a misdemeanor. Of the violent cases we have in the county, 20% of the cases that are felonies, and the much smaller subset of that, which are violent crimes, that's where we're prosecuting gang members. And even there, we're very selective. We're only charging gang enhancements about half the time on those violent murders, attempted robberies, assaults, carjackings. Even if a gang enhancement is not charged, there still may be multiple defendants charged with a carjacking, with an attempted murder.
Right.
So there'll be additional costs for the defense if we charge a case involving multiple defendants. Of course, we want to make sure that we bring accountability to everyone involved in a violent crime like that, as I'm sure most of the community would prefer as well.
Thanks. I appreciate that distinction, and that the enhanced charge doesn't necessarily mean more individuals are added to it. I have just a couple more questions. I know I'm taking a lot of time, so let me try to be very quick with the last two. I know that there are multiple gang task forces that you work with. Are they all funded through state and federal dollars, or are general fund dollars at play in any of the gang task force work?
Well, by gang task forces, of course, in San Jose, there's the mayor's gang prevention task force, which is a consortium of police and DA and sheriff and community groups. In terms of the police department in San Jose has a unit which focuses on criminal street gangs, and that's funded by the city. And within the DA's office, we have a number of prosecutors that are on the gang team. In terms of coordination that we do with other counties, there are regional gang task forces, but that's not getting any additional funding. That's just part of what a gang detective would do or a gang prosecutor would do in terms of having regular meetings with their counterparts. So,
okay. Thanks. I really appreciate all of that information. And I realize that finances sometimes feel very discrete from public safety and justice, but from where I'm sitting as a policymaker and someone who's going to be asked to approve a budget in a couple of weeks, it's important to hear how it all fits together. So thank you very much for that. Supervisor Wasserman, do you have additional questions or comments?
Just a couple of comments. One, I want to say whenever I see a presentation by ADA CAPS, I learn something new. And I want to thank you for that and for your slides. And the report that was written up was quite educational. I also want to thank DA Rosen for mentioning the other side of every crime. Oops, there we go. And that's the victim. And I know we're always looking at who's committing a crime and where crimes are and all the rest, but the victim's very important too. And it was the report that DA Rosen came out with 5 years ago and has continued each year since, that I found fascinating. I was in your seat, Supervisor Ellenberg, as chair of this committee 5 years ago when that was brought forth, and each year thereafter. And it's very, very interesting, because to recognize the victims, you know, we're often wondering about why the overrepresentation of one ethnicity or another in committing the crime. There's the overrepresentation of a couple of ethnicities that are the victims of the crime. And I'd sure love to be looking to do something for the victims of the crime, because we spend so much attention and money on, I don't know if perpetrators is the right word or not, I just get that from TV, but the people committing the crime. And you know, who committed the crime and what are we doing, and did we do the right procedure, and what's happening in jails, and da 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 da. And all of that is about the person who committed the crime or allegedly committed the crime. And so I'm glad to see, DA Rosen, the emphasis and the attention that your department has brought to the victims of the crime. Thank you.
Thank you very much. Do we have public speakers on this item?
We do, Madam Chair.
All right. I assume we don't have more than 5, so let's do
We
2
have
minutes,
one.
please.
Okay.
Let's do 2 minutes, please.
Thank you. Our next speaker is Susan Bassey. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
First of all, on reading this report, Jeff Rosen continues to do what has kept him in office for a very long time, and that is create fear over gangs, which primarily happen in Gilroy, our South County areas, and east sides of Palo Alto. What has been forgotten, and Mr. Wasserman, it is not the other side being the victims, but the cases that Jeff Rosen does not prosecute, and that's the white collar crimes. He is currently being sued related to a white collar crime involving ghost real estate. So while he tries to incite fear with the voters who will keep him in office, that people are going to shoot them on the streets or steal their purses or commit murders because they're part of gangs in our undereducated and our poorest communities, what he is forgetting to tell you is the number of people who are engaged in white collar crimes that he has given a free pass to over the last 10 years. And that includes the case that he just prosecuted with SEC and real estate crimes involving the Houghtons, where Valerie Houghton was an attorney and Terry Houghton was an Intero real estate agent. And at the end of that case, Mr. Rosen decided to dismiss it after 4 years. There was no consideration of the victim who lost $3 million or whether there were other co-conspirators. But it was determined that one of the defendants in that case had fraudulently obtained the IDO services. That means that we have rich white attorneys and real estate agents associated with Intero real estate involved in real estate crimes that our DA is giving a free pass to, that is costing taxpayers money because they're committing fraud. And Mr. Rosen is more interested in running around after phantom gang members that he can help keep him in office because he creates fear in this community. We have to stop letting him do that. You have to stop giving him the money to do that. You have to stop looking at victim programs that actually work instead of letting him create.
That concludes our public speakers.
Thank you very much. We'll move on to item 6, which is to receive a report from the Office of the Sheriff relating to quarterly inmate grievance trends. And what I'd like to ask, if I have the agreement of Supervisor Wasserman, is whether we've certainly seen the report in our packets prior. It's been posted with the agenda. If we could go right to questions rather than going through the slides first. Is that all right with you, Mike?
Yes, ma'am.
All right. So I do have some questions about some of the, it's very echoey.
That should fix it. Go ahead,
There
Chairperson.
Thanks, Dave. You are magic. So first to the Sheriff's Department, I want to thank you and your department for the work on this grievance report. You've provided a significant amount of new data and analysis, as well as the raw grievance numbers for each facility. And I just want to express appreciation for that. I do have a few clarifying questions, which might be worth putting the slides up just so that we can reference them, if that's all right. On slide 9, the trend data on the highest grievers. I'm interested in knowing more about. Can you share what support either the Office of or the Office of Mediation and Ombuds Services will provide to those individuals, and what their policy is for addressing grievances?
Yes, thank you. I will, Captain Sepulveda is on the call, and also Lieutenant Nguyen from the grievance unit, and I think that they can provide you additional information.
Perfect, thank you.
Good afternoon, supervisors. In regards to the Ombuds partnership, we added the information and the data to highlight the partnership that we collaborate with the county's Office of Ombuds and Mediation. So at the beginning of the fiscal year, we took data from July 2020 to December 2020. We identified 20 inmates, and that equates to about 1% of the population, actually less than 1% of the population between all three facilities that together combined for 16% of all submitted grievances during that 6-month period. So at the beginning of the year, the grievance unit partnered with the county's Office of Mediation and Ombuds Services, and we provided this group of inmates with an alternative means to address their concerns. So this collaboration between the grievance unit, the Sheriff's Office, and the Office of Mediation and Ombuds Services is designed to provide the grievant with an opportunity to practice resolution skills, understand all of their options in handling situations or events that may have upset them. Each inmate in this group received a notification advising them of how they could reach a neutral mediator directly from their housing unit by dialing an extension that could reach a neutral mediator from the office. The mediator will listen to their concerns, help surface unmet needs and interests, and coach them on potential next step options. Since we sent out the notifications, we started tracking its effectiveness. And to this group, we noticed a substantial reduction in grievances from all three facilities. When compared to the previous 6-month period, the main jail group of 10 inmates reduced their submission rate by 75%. The Elmwood men's group of 6 inmates decreased their rate by 69%. And the Elmwood women's group reduced their rate by 85%. The grievance unit plans on reevaluating this list every quarter and will extend the option to add more inmates that may benefit from the service. So since the last submission of the ledge file, we did reevaluate the list, and we extended it to another dozen inmates or so, and we will track its effectiveness and report back on the collaboration between the two entities.
Did you say 85% decrease with women?
Yes.
That's
85%.
remarkable. Through working with the Ombuds Mediation Services and essentially learning a new skill of a way to address their concerns?
Yes, that is correct. Yeah,
Really?
a group of women's inmates reduced the rate by 85% from the previous 6 months.
Interesting. Thank you. I really appreciate that detail. Slide 16 is new data on COVID-19 related grievances, but the categories that are listed are the same that we see for the general grievances. So help me determine how or which grievances are COVID specific.
Let me pull up the slide on my screen real quick. 16. Oh, sorry. So slide 50. Let me see if I can share my screen. Sorry.
Do you want to? Oh, there you go.
Can everyone see my screen?
Yes.
Clearly? Okay. So slide number 14, right here.
I was asking about 16.
Oh, I'm sorry.
That's all right.
Oh, okay. So slide 14, 15, and 16 have been packaged together. Slide number 16 is basically all of the categories that were COVID related for the 12-month period that we started tracking. So our grievance unit started mining for this data back in March 20 to see how many grievances were related to COVID-19. So we started tracking that independently from all the other reports. And based on the data, we collected 12 months worth of data. And these are all the categories that were in relations to COVID-19 grievances that inmates were complaining about during the last 12 months.
One of the in the attachment to the report, one of the highest grievance categories across all facilities was medical accommodations, which I assume is probably highly correlated with COVID. Can you provide any context for the type of accommodations that people were requesting?
Generally speaking, during the last 12 months, inmates expressed their concerns with medical testing as in regards to COVID. And, you know, the collaborative effort between the classification unit, medical services, as we see in slide 15 right here, every single time there's a peak in COVID-19 positive cases inside the facilities, as marked in August, December, and January. It seems like it's a reactionary, for the inmates, it seems like a reactionary cause and effect. So whenever there's positive cases out of facilities, we notice that keep in mind, this slide number 14 is completely independent from all the other data. This is data that we collected from the grievance unit based on content. We see the same peak and valleys as slide number 15 right here. So as medical services and classification work together to isolate individuals, we started seeing increase in grievance complaints across the board. So every single time there's an outbreak per se, we see an increase in grievance submissions for across all three facilities.
Thank you. And what rights do inmates have to be able to be kept separate from correctional officers who have declined the opportunity to be vaccinated? I understand it's still a fairly high percentage. Do the inmates know who has been vaccinated and who hasn't? And for the correctional officers that have not been vaccinated, do they have the same access to people in custody that they could, you know, obviously potentially expose to the virus?
So this is Captain Sepulveda. Good afternoon, everybody. So Chair, we do not disclose who is vaccinated and not vaccinated. But what is important is that the staff are required to follow all the COVID-19 protocols with regard to masking and sanitation. So we basically make sure that everybody's following the proper protocols that are set in place, and we don't disclose that information to the inmates. So with regard to isolation, it's really about those who have tested positive and have been put into a quarantine dorm and or were exposed. So classification works directly with our medical staff in determining which inmates are under that criteria, and that's generally how that process works.
Yeah, I understand the privacy piece. They're still at higher risk though, so that remains concerning to me. Just my last point I wanted to follow up on. At previous meetings, I've requested that the department conduct a client satisfaction survey to determine whether inmates feel the grievance process meets their needs. Of course, a significant drop in grievances could either mean you're doing a great job in resolving them, or the system is just not working and people have given up. Can you share what the status is of the survey? Was there an update?
Yes, so we had begun working on the survey, and our option was going to be using a similar style that we did in the past, where we bring in tablets and have volunteers go and provide the survey to the inmates, so that they don't feel like it's forced upon them or anything like that. So when COVID hit, obviously we reduce the amount of folks that are allowed to come into the facilities. And so we're still under those same protocols, but we still plan on pursuing our survey as soon as things get back to normal a little bit.
So I'd like to direct the department to bring to the next PSJC meeting a work plan and timeline for conducting that survey, please.
Okay, will do.
Thank you so much. Supervisor Wasserman.
No, ma'am.
Any public speakers on item 6?
We currently have 2 public speakers, Madam Chair.
All right, let's do 2 minutes. And sorry, before we start that, Molly, did you want to speak or say something first?
Oh, no, I was going to introduce our agenda item number 7 speaker. So I didn't realize we had public comments.
Gotcha. Give me just a minute. I'll come back to you.
Our first speaker is Susan Bassey. I'm unmuting you. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking. Susan is not unmuting. We will come back. Next speaker is Scott Largent. I'm unmuting you. Please accept the unmute. You'll have 2 minutes to speak. The timer will start when you begin speaking.
All right, great. Thank you, everybody. Thank you, everybody. Saved by the bell on that one right there. I have dealt with using the ombudsman services through our county. And for me, it kind of seemed like a little hidden treasure that a lot of people don't really know about. It's like it's like the yard duty getting involved on the playground in a way. Certain things don't need to end up in the principal's office. Certain things don't need to end up, in front of the teacher, and it can be taken care of. This is a really good program. I dealt with Carlos Aller. I'm sorry, it's Alarcon. I don't really want to butcher his name. And he was the senior mediator, and it's the Office of Mediation and Ombudsman Services through Santa Clara County. So I believe that's who you're talking about that's getting involved with some of these jail complaints. This whole process was dynamite. He pretty much got involved. It wouldn't have had to require, I was trying to do civil standbys. I was trying to get my stuff out of a place. And when you kind of have the backing from the county in a way, and you have a nice gentleman that's used to dealing with people and dealing with conflict, I thought to try to get my stuff for 3 or 4 months. This guy made it happen in about a week. And I was very thankful for it. It was a no-cost service. And it took care of a problem fast that could have gotten really bad. And especially when you're calling law enforcement or getting them involved. So I'm just saying that this is a treasure right here that maybe the public just doesn't know about. I think this was explained to me when I was first going to meetings that there was an ombudsman. I just never have heard of that word. I didn't know what it was. I didn't know, I just was really clueless in the beginning of things. It seems like this is something that should be at the front of issues in our county. So it was a pleasure dealing with Carlos from there. Did a great job. So thank you.
We'll try Susan Bassey one more time. Susan, I've unmuted you. You'll have 2 minutes to speak. The timer will start when you begin speaking. We are not able to hear Susan, so that concludes our public speakers.
Thank you. We will turn then to item 7, which is to receive a report from the Office of the Public Defender relating to the pre-arraignment representation and review team, PARS.
Thank you, Supervisor Ellenberg, and thanks for the opportunity for us to highlight our office's efforts on early representation. I'd like to introduce Assistant Public Defender Charlie Hendrickson and Deputy Public Defender Carly Ware, who are here to report out to the committee on our amazing efforts in this regard. Thank you.
All right, thank you, Molly, and good afternoon, Supervisor Ellenberg, Supervisor Wasserman, and committee members. Carly is going to put up a PowerPoint presentation. Oh, thank you, Carly. Carly will be describing the program and our recent launch of what we call rapid representation. Carly is our dedicated PAR attorney, and she really is the engine that makes this program run. Carly, can you go to the first slide? Thank you. Before I turn it over to Carly, I'd like to offer what Molly and our management team see as the emerging standard of care for public defense agencies. First, on the left there, The California Supreme Court recently decided in Ray Humphrey. It was a unanimous 7-0 vote, which I think is significant. Humphrey says that all persons held in custody have the right to have a judge make an individualized determination regarding the setting of bail and possible pretrial release conditions. So judges may no longer reflexively set bail based on arbitrary bail schedules, but instead must consider the unique life circumstances of each person that appears before them. The second issue is what we call charging advocacy. And our DA, Jeff Rosen, recently announced what I think is a very important policy change. And the Santa Clara County DA will no longer make charging decisions based on what they can prove, but instead what they should prove. And that necessarily brings into play race and equity considerations. And he invites defense attorneys to provide information that's relevant to those decisions so they can factor that into charging decisions. So that gets us back to the standard of care. When you take those two things together, what Humphrey did and what DA Rosen announced with their charging policy, we believe the standard of care for public defenders is to gather reliable and robust information about our clients to present to both the judge and the DA, and then to do that at the earliest practical time. In truth, though, these two concepts are not entirely new. For years, private defense practitioners have advocated for their paying clients in just these ways. Our early representation program is about closing the gap on wealth disparity in the representation of indigent persons. Carly?
Thanks, everyone. My name is Carly Ware. I am a public defender here in Santa Clara County. I've been a public defender since 2009, and I was asked to launch and design our PAR program in September 2019. PAR stands for Pre-Arraignment Representation and Review. The review means bail motions. And just in the last year, our team has litigated 50 bail motions in court before judges to give clients their day in court about pretrial release. But our primary function is supportive intervention and advocacy at the earliest stages of criminal prosecution to reduce the duration of pretrial incarceration. So we received some media coverage when we first launched, and the headline in the Mercury News was a new public defender program looks to even the playing field, but that's an incomplete description of our program. It's truly collaborative. The district attorney's office, especially pretrial services, has really enabled this program to launch and to be successful. One of our missions, like Charlie just touched on, is to eliminate wealth disparity. We all know that if someone can afford bail and a private attorney, their first day in court is going to be very different from someone who is showing up with no legal services until they reach court. Another one of the reasons that we believe so strongly that this program is important is we want to protect against the harms that flow from even brief periods of incarceration. There are studies that show that incarceration just for a few days can impact a person in profound ways, including job loss, housing instability, and child custody issues. And I'm displaying this chart here on this slide, which is actually our county's implementation of a penal code, which is Penal Code 825, which sets forth the time limit for someone to be brought to court for arraignment if they are in custody. And this is for arrests that happen without an arrest warrant. So I want you to imagine right now that a person is arrested on a Friday night. So it's Friday night, and let's say there was a dispute, the police come to that dispute, the law enforcement officers that respond determine that there's probable cause to make an arrest. So they do their job, they make an arrest, they deliver that arrestee to the jail and book them into the jail. Many of you on this meeting will be familiar with a computer program at the county called CJIC, and it stands for Criminal Justice Information Control. When the person that's arrested is booked into the county jail, this CJIC computer program will automatically generate a placeholder arraignment if the case is filed, so we know when arraignment will be. And this chart tells you when that automatic placeholder arraignment will be generated. So for a person arrested on a Friday night, they will sit in jail Friday night, Saturday, Sunday, Monday, Tuesday, and Wednesday morning until they're brought to court on Wednesday afternoon for arraignment. And our current model of how we provide services to those folks that are in custody that cannot afford bail, I believe, is outdated. Pretrial Services does a brief interview to present information to the magistrate that reviews the case to see if there's probable cause. That magistrate will set bail. And if the person can afford bail, they are released into the community, and their court date, instead of this on this chart, it will be set forward 60 days or so to an out of custody arraignment date. If the person cannot afford bail, they will sit in jail and not receive any legal services until they are formally charged at the court date, which is called arraignment. And that's where public defenders under our current model meet their clients for the first time. We want to change that model and make those days that if someone is in custody productive, so that we're connecting them to services and we are linking them back to their community. Now, in our first 6 months of operation, it was before COVID, so we were able to operate on a model of in custody, in-person visits between arrest and arraignment. We had a team of attorneys and investigators that would go out to main jail in Elmwood and engage directly one-on-one in person with people who had been arrested before their arraignment. So that when they come to court, they're seeing a familiar face and we have some information about who they are and who they're connected to in the community. And for those clients in the first 6 months that we met before arraignment, 67% of those clients were released at arraignment, either on their own recognizance or on supervised release, because a judge determined that it was safe to release those people without any cash payment of bail. The work that we did between arrest and arraignment just emphasized outreach to folks' existing resources and family members. We'd call employers and make sure they know that even though their employee might not be coming on Monday, that on Wednesday they might be able to come back to work if their job was waiting for them. Then we'd tell the judge, Your Honor, there's a job waiting for this person if they are released, and it would reduce instability. We also reached out to the district attorney's office and did early investigation on cases where there might be witnesses or video surveillance that wasn't collected by law enforcement, but the defense might be able to obtain. At the heart of this program, really, it's rooted in understanding and viewing our clients as our community members and our neighbors. As a public defender, I believe that 99.9% of my clients are going to return home. There's a process first where they'll be brought to court and there'll be processes to hold them accountable if evidence is presented, but they are not going to be in prison or jail forever. They're gonna get out. This picture that's displayed on the screen demonstrates one way that I linked to one of my clients. This gentleman, the barber in this photograph, is someone I met in the very first week that the car team was operating. He was in custody for a dispute with his roommates. And I was able to learn from him all about his life and appear with him at arraignment. He was released on his own recognizance. And my son is the boy in this picture who badly needed a haircut. And so we went and visited our client in the community at a barbershop and got a haircut. It's just one way I think that demonstrates that public safety really is a network of people that need to work together to make us all safe. I'm really proud of this next slide. Because defense attorneys have been invited to the table, these processes that have been occurring for decades without anyone from our perspective viewing them now can be reviewed. And we brought about systemic change that I believe has helped the county. When we speak to people that are in custody and we can tell them when their arraignment date will be coming up in the next few days, we tell them that the district attorney's office will become involved in between the arrest and the arraignment. A police arrest just results in a booking. It doesn't result in formal charges being filed unless the district attorney's office reviews the case and decides what charges are appropriate and files those charges in court. We were noticing that some of the people we were speaking to in custody, the district attorney's office was promptly reviewing those cases to determine whether there was evidence and whether they wanted to file a charge. And in some cases, the district attorney's office declined to file charges. The district attorney's office rejected the case. And we learned that that decision by the district attorney did not link to release from jail. The jail would still hold the folks for that placeholder time period that was displayed in CJIC. PAR brought that concern to the attention of stakeholders that are involved, and everyone that we collaborated with took it very seriously, responded promptly, and changed the computer programming and the protocol involved in this process. So now, when a district attorney reviews a case and determines that it should not be filed and rejects the case, that decision triggers immediate release because of our work. We had to change everything when COVID hit because our model was based on personal visits at the jail in custody in person, and we just stopped doing that in March 2020. But we pivoted and we came up with a new model that, thanks to the leadership of Supervisor Chavez, the Reentry Network, the County Executive's Office, we were able to change our focus and use these tablets that we've all heard about for virtual access. So now what we do is we've joined with the Sheriff Department as partners, and we've changed the booking process so that part of a person being booked into custody involves accessing an attorney or an investigator from the Public Defender's Office before they're even housed at the jail. We use tablets and we work shifts where we will connect with people right after their arrest and before they are housed to discuss with them the process that's going to happen in terms of just criminal prosecution and all the decisions that will be made. We launched this new tablet procedure, the Rapid Representation Program, just a few weeks ago at the end of February. In our first 4 weeks, we had attorneys like me working the tablets on weekend evenings. I work on Friday night from 6 p.m. to midnight because those clients are brought to arraignment on Wednesday when I work arraignments. And after 4 weeks, we had public defender investigators join, and they now staff daytime shifts on the tablets. And the sheriff is a valuable partner, and we really appreciate how much flexibility that the deputies in the jail have worked with us along with pretrial services to enable us to access our clients as early as possible. To give you an example of what a typical shift will look like for me when I'm working on a rapid representation tablet, I will ask the pretrial services officer and the sheriff's deputy that's working in the jail on my shift, once I've identified a potential client, to put them in a confidential meeting room with a tablet. And now we have headphones because the rooms are so echoey that we're having trouble hearing each other. So the client goes in a confidential meeting room, and I talk to that client after receiving their request for early representation for as long as they need to talk. Sometimes it's 10 minutes, sometimes it's an hour. I answer all their questions. I advise them about the process that's about to happen. I talk about bail, district attorney charging decisions. I'll get their family's contact information, and then I'll end the interview with the client. And then I will contact anyone who it makes sense to contact for that individual client. I'll call people's mom, loved ones, tell them about the court process and the bail process. We'll have investigators sometimes initiate investigation or reach out to employers. We'll call parole and probation officers. We'll contact the night judge if we're able to, and the district attorney's office if we feel we have information that will affect the charging decision.
I'm unmuted. Thank you, Carly. So these are what we see as the challenges as we work through this, this new process. One is that we are at the jail 45 hours a week now, either with our attorneys or investigators. And we want to engage more of the folks that are booked during those times. Unfortunately, because the jail is under certain pressures to get people transported and housed within time limits, sometimes and many times our clients are transported before the attorney or investigator interview can take place. We're working with our friends at the sheriff's office and with pretrial services to figure out how to identify who our booked clients are earlier, so hopefully they can get to an attorney interview before they get housed. If we're there 45 hours a week right now, and there's 168 hours in a week, we'd like to be getting that percentage of clients, somewhere between 25 and 30%. And we're not doing that right now, but that's our goal. Secondly, obviously, since we don't staff rapid representation at booking 100% of the time, there's a number of clients who would never have the opportunity to participate in this because they were unlucky and didn't come at those times or weren't booked at those times. So we need a method to essentially engage those people between the time of housing and arraignment. We currently do have tablets in the jail for Zooms, but they require a 1-day lead time. And then that, in most instances, precludes us from doing a interview and advisement prior to arraignment. So we will need to work on that and work with our partners to figure out how to efficiently engage them. One other thing that's really important component of this that we are looking to expand into is that Carly and her partner in the PAR program, Carson White, who's our fellowship attorney who's since moved on, they identified Penal Code Section 1269C. And what 1269C says is that defendants, through their family members or their attorneys or themselves, actually have the right to, in most instances, provide information to a night magistrate that would be relevant to release prior to even getting to arraignment. We never have participated or advocated for our clients in this way, but now it's plain that they have the right to do it. We are working with pretrial services to figure out a way to take our PAR information, marry that to the pretrial services report that goes to the night judges, and so that they can consider the additional information that we gather. I'll let Carly handle the concluding slide. Thank you.
This is our last slide. And before I talk about it, I just want to share with you what the experience is like for me as an attorney working on an arraignment calendar right now. So on Wednesdays, I do the felony arraignment calendar for in-custody clients in Department 24. And the typical caseload that on Wednesdays is anywhere from 25 to sometimes 50 clients that are on calendar in court. I can't meet them before court. Just like logistically, I don't have access to them before court starts. And the discovery, the police report, the complaint, all the information I need to talk to the judge about whether release is appropriate and safe is not provided to me until about 10:30 in the morning, the day of court at 1:30. So between 10:30 and 1:30, I'm scrambling, reading police reports and case files. And at 1:30, I come to court and I'm scrambling to give each individual the dignity of a personal conversation about their most intimate details of life so that I can figure out whether it's safe and appropriate to ask for their release. Well, we want to change the model so that the time between arrest and arraignment becomes productive, and that when we present information to judges at arraignment, that it's information that helps the judge make a fair decision, and to address Supervisor Wasserman's previous concern, that helps address victim safety as well. Because if we have a safe release plan for our client that's going to work in the long term, we feel more comfortable presenting that for our community as a whole. Thank you.
Carly and Charlie, thank you so much. That was an absolutely fascinating report, and I'm just really impressed to hear more about the work of the PAR teams, especially the quick pivot to virtual interviews in response to the pandemic. Grateful to my colleague Supervisor Chavez for her leadership there. I was alarmed to learn that there were over 2,700 individuals who had been over-detained. I think that's the phrase, over-detained beyond when the district attorney had determined that they would decline charges. And clearly any amount of time spent incarcerated is disruptive and traumatizing. And I was glad to hear that the issue has been resolved. Can you tell me what is a reasonable expectation of time that it should take between when the sheriff is notified that the district attorney has declined charges and when an individual is released from custody?
Professor Ellenberg, just to be clear, what used to happen is there was no communication about it at all. And what's happening now is collaboratively they've fixed it. So are you asking,
Yes.
once they get notice, how long should it take to process someone out of the jail, or how long should it
Yes.
take for notification?
How long should it take from the time the district attorney says we're not going to charge until the person walks out the door? I understand that you are working together now, but I don't have a sense of what that time period is.
I think I'd like it obviously to be immediately, and I suspect and the sheriff's office are in a better position process by which someone is released.
Is it immediate? Sheriff Smith, what's a reasonable time?
It really depends on a lot of factors. If they're still intoxicated, they stay for a minimum amount of time. It depends on the workload. It's a two-part system where it goes to admin booking, and then it goes to admin booking, and then it goes to the jail. So there's no real time from the time of the notification. But I think what's really important in here is the collaboration that everyone did within the system to make sure that we could be notified of them failing to not filing charges on things, because in the past, they would very often stay in custody if they were not released otherwise. They would stay in custody until they went for arraignment, and then the charges weren't filed. So it saved our transportation people a lot of work because of this collaboration.
It has absolutely improved, but can you estimate for me what period of time? I don't know if we're talking about minutes or hours.
Go ahead.
Yeah, let me take this, Supervisor. So essentially, once that communication is made to our admin booking and there's a diag sent over to our jail staff, we have release staff on duty 24/7 essentially. So once we get the document that determines that a release is due, they just go right on the next wave of releases. It could be as immediate as 30 minutes, but depending on what time of the day or night, it could be up to a couple hours. It just depends on what's going on operationally. But once we get that diag, we're really interested in getting them out as quickly as possible.
Sorry, what's a diag?
Oh, it's basically a notice from admin booking to the jails advising us that this individual is scheduled for release.
Got it. Thank you very much. I appreciate that.
And if I can also add, there are many times where they're released before it's determined whether or not the charges are issued. For instance, we have a policy that we've worked with the courts on the sheriff's office citing and releasing them. And for many of the minor charges, they're released before there's a determination of whether charges would be filed.
Thank you. I appreciate all of that. And I appreciate, Carly, the number of times that you talked about everyone's responsibility and the importance of working together in the interests of real public safety. So thank you for a terrific report. Supervisor Wasserman, do you have any questions or comments?
Thank you. I've got a comment for Carly. The changing of the model that you brought up in your presentation, the changing of what exists now into a different model. Carly, how does that, I understand the collaboration and there's a lot of moving parts and different people involved at different hours and different times and different access and different concerns and all these different things. The model that currently exists compared to some changes that you're advocating for, who changes that model? How does that model change? How does the status quo change?
I don't mean to answer for Carly, but if I could just say a couple things, and I'm sure she may have more to say. We traditionally have done all the work later. So the way the model changes is we start earlier, we start sooner. It's.
And Molly, if I may, when you say we start, do you mean the public defender's office starts? Who's the we?
Yes, the we is the public defender's office. So we're talking to our clients way sooner, and we're gathering information about their lives and their jobs, where they live, the support systems they have way earlier. So it does involve other partners. We need the sheriff's office to facilitate our conversations with people who are just booked into the jail. We need pretrial to work with us to get information to the night judge. So it's it will take the whole village, but it really starts with us. So Charlie and Carly, if you have anything else to add, feel free.
Go ahead, Carly.
I would just say that when the district attorney makes a charging decision, that triggers an obligation of the public defender, if we will be counsel, to know everything that the district attorney knows at that point. And so I think there's been some challenges for us to receive the information that the district attorney has. It's all done electronically now. It used to be in arraignments. As an attorney, I would stand in court and I would appear and ask to be appointed. And then literally I would get an envelope handed to me in court, and it would have the police report and the complaint inside of it, and they would open it in court. Now we're able to get it electronically, but it's been, I think there's a lot of room for improvement for how quickly it can be transmitted to us.
Gotcha. Thank you.
Just briefly.
Oh, yes, Charlie.
Yeah, thank you, Supervisor Wasserman. Traditionally, our model was that we first met our clients at arraignment. And that was that kind of process that Carly was describing for you. And we had very little information on our clients, and it seemed to be, it's unfair. It's not a good practice. So I might meet a client for the first time in court. He walks in. I have a copy of the complaint. I read it to him. I check to make sure that that's his correct name and date of birth. I otherwise know nothing about this individual in front of me. And yet the judge is about to make an incredibly important decision on his behalf, which is, are you eligible to be released on bail or on supervised OR or OR? And if so, what information do I need, the judge, to make that determination? And I can say to my client, the judge, Your Honor, I've just met Mr. So-and-so. And my client tells me that he's employed and he has a wife and children. And he's lived in this community for 25 years. And the judge says, do you have anything that corroborates that information, Mr. Hendrickson? I do not, Judge. Well, I'm going to set bail reflexively at bail schedule, $25,000. And without prejudice for you to renew a release motion at your next court date, I'm going to continue the matter for 3 weeks for plea, and you can renew it then. And then we don't really see that client until we interview them in between the plea date with a paralegal. And then the next time we have a robust representation of that client is at the plea date 3 weeks from now. What we know is that the impact on our community of losing that amount of time to being in custody, you might lose housing, employment. It's very destabilizing. What Carly's describing, like the gentleman and the barber who cut her son's hair, she was able to meet that gentleman, unpack this kind of silly story about a family dispute, do advocacy with the DA, represent to the judge at arraignment his connection to the community, his requirement of getting back to work. And she resolved that case, which was booked as a felony for a misdemeanor, and he was released from custody that day, just in time to cut her son's hair. So that's what we're talking about. The model has to be now, based on what Mr. Rosen has said to us, which is bring me reliable information early so I can make equitable charging decisions.
Got it.
And the judge needing reliable and robust information to make release decisions. We think that is the standard of care. The issue is, how do we bring this to everybody and not just the few people that we meet on the hours we staff rapid representation?
Gotcha. Charlie and Carly, thank you both.
Thank you.
Thank you all very much. Do we have public speakers on this item?
We have 2 public speakers, Madam Chair.
All right.
Our next speaker is Scott Largent. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Thank you, everyone. Scott Largent. This really sounds like great work. You know, going through this process when you're arrested or going through the courts can be very, it's just very hard to deal with. And if you don't know how to navigate the system, you do need somebody to hold your hand. Getting to know the client, I think, is very important. Sitting down with them prior to the arraignment. This looks very impressive, but I think it's missing one piece, and that's property. Normally, when somebody's arrested, they would have their vehicle towed. If they're homeless, they're normally not getting that vehicle back. And in my situation, I had to run in circles, and I spent a lot of time at that public defender's office. I spent a lot of time talking to receptionists. I spent a long time trying to get a hold of this attorney. And since it pretty much wasn't assigned and I had to wait until arraignment, you guys know the process of what happened. If an investigator would have gotten involved early, they could have figured out that, where my property was at. Having an attorney go to bat for me with the tow company saying, hey, this guy needs to get his stuff. That scares people. That makes businesses act and take care of their responsibilities. Plus, the public defender's office could have gone over these forms and realized, hey, they're not lien sailing these vehicles properly. And you guys talk about gathering this information, figuring out things about the family and the living situation. We have to focus on the people that have it the hardest in our community. We really do. And those are most of your clients there at the public defender's office, Molly. And we need to look into what is happening to these motorhomes and cars and get Jeff to do his job and prosecute these tow companies. This stuff is wrong.
Our next speaker is Susan Bassey. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Can you hear me this time?
Yes.
Okay. First of all, I want to, since the mic wasn't working last time, I want to add my comment on the sheriff's report. And that is that a lot of the stories, the work looks really good. And a lot of the stories have been, however, reduced to a statistic. And in doing that, you are missing the point of what is really happening to people inside the jails that could be an easy fix during COVID or during any other time. For instance, the commissary, that is a lifeline for so many people. To just shut it down and not notice what the impact of that is a problem. And so if you need help with storytelling, I will do it pro bono because I'm getting the stories anyway. As far as this issue with the public defender's office goes, we are failing the poor, the undereducated, and the people that we've put into the system because of our overzealous prosecutor who has prosecuted the poor and the most vulnerable in our communities. It is not even always just a race issue. It is a matter of Mr. Rosen having these people on a cycle where they just keep coming through and their lives are further ruined. We have to have our public defenders stepping up more. We have to give them more tools and resources to be able to match what the DA's office is given. Giving Jeff Rosen's office all of the services, the grant money for victims, and everything else in this community is not working. It is too imbalanced, and it is creating the corruption and the injustices in our court systems. And that is not being reflected in these public meetings because of the pattern and practice of this county stifling dissent and violating First Amendment rights of people who need to be able to speak up about these issues. So the complaint processes and the communications need to be coming forward to you in a way other than just the public and elected officials in this county. Thank you.
That concludes our public speakers.
Thank you very much. Oops.
There you
go. We have run a little bit long today. There's a VTA meeting that is happening here in a little bit, and we need to give our clerks and staff a bit of a break. So what I would like to do is go to items 9 and 10, which I had requested to hear together. Thank Dr. Day for submitting the reports. And Supervisor Wasserman, do you have any questions?
You're talking about 9 and 10 now, correct? Any questions?
Yes, sir.
Thank you. On item 10, what I was wondering was in the future, if this could be simply an off-agenda staff report for us on item 10. That would be my suggestion for your consideration.
For my consideration or for Dr. Day's?
Well, no, if you and I agree it can be an off-agenda report, then it can be an off-agenda report. So that's what I was putting out to you just for future.
Got it.
And other than that, I do not have a question.
All right. Do any of the committee members have questions? All right, then we will consider the reports received. Dr. Day, thank you very much.
Supervisor Ellenberg, if I can make one correction, please.
Oh, absolutely, please.
I just want to call attention to a correction on page 2 of the legislative file 105780, to where it reads Alameda County Behavioral Health Services when it should read Adult Custody Behavioral Health Services.
Ah,
Thank you.
which makes more sense. Yes. Thank you very much. I appreciate that.
Thank you.
Do we have comments, public comments on items 9 and 10?
We have one public speaker, Madam Chair.
All right, sir, let's do it.
Our next speaker is Susan Vassy. I'm unmuting you. Please accept the unmute. You will have 2 minutes to speak. The timer will start when you begin speaking.
Yes, this is Susan Bassey. Can you hear me?
Yes.
First of all, Susan Ellenberg, you know I will be the first one to call you out on any misinformation or any of the work that you're doing that the community views is off skew. And I do want to say that other than not knowing what a PC 148 is, which is absolutely naive in this day and age, you are doing a really good job of trying to figure out these issues, but you have to allow the voices to bubble up. As far as issues in the jails, we have a fact that only 40% of our law enforcement officers in this county want to get a vaccine. We cannot force them to get vaccinated if they're working in the jails. You can do reassignments and you can do other issues if you believe that that is important. The other thing is we should be offering vaccines to everybody upon being booked into jail. If they want it or not, they should be given the option to have it instead of being terrorized in the jail about whether or not they will contract COVID simply because they have been arrested and booked. They haven't been found guilty. We don't even know if we've made the right arrest. And based on Mr. Rosen's pattern and practice and his history, it is a concern that we all need to consider because we are terrorizing the citizens of this community. We are terrorizing people who are arrested, and whether it's for domestic violence or other crimes that will have to work through the legal system. We shouldn't be terrorizing people in the middle of a pandemic while you all sit in the safety and comfort of your offices at your full government pay. That is not right, it's inhumane, and we have to come up with a better way to do it. We cannot force people to get a vaccine. That is a political agenda right now in this county that people are trying to enforce. You cannot do it. Everyone has a right to be able to decide what they're going to do about that, and we will have to, as a society, deal with what we do with those who are not vaccinated. Thank you.
That concludes our public speakers.
Thank you very much. And with that, we move on to item 11, which are department head or court announcements or supervisor announcements relevant to the work of this committee. Is there anything anyone would like to share today? All right, then I will declare this meeting adjourned until our next regular meeting of the Public Safety and Justice Committee on Thursday, June 3rd at 2 p.m. Thank you very much, everybody.
Thank
Take
you,
care.
everyone.
Bye.